Hello, I'm here today because I am very interested in focusing on those things that I can do in my life to make my reality be what I want it to be, and to share with others anything that is empowering to our standing for our families. I think that there's too many distractions out there, and I think that what I see is a lot of people tearing others down instead of building them up. And so my focus is going to be on helping to shed the light on things that are going on that I do not want to see anymore in the world, and how we can together unite to bring an end to this. And my focus has been on human trafficking, the legalized form of state-sanctioned kidnapping that is impacting so many lives today, including my own. So in order to rise above this all, we have to use our voices, and we have to put into action the very things that we want to see in our own lives, because we create our reality. Those things that we focus on are what grows. And so whether it be other people are coming against us or not, we have the ability to focus on those who are serving us and the information that is serving us, and to just shine our light where we want to be going, and on those things that are dark and trying to hide. So that is why I have this picture on the screen. This is my 3 daughters, and it says the Missing Northwest on Twitter, because they have this big system that's together that works together in order to deceive people and to distract, and they want to be the authors and the ones telling the story, but it is each of us, all of moms and dads out there who are in this battle, that are the ones who actually hold the pen and are able to write our narratives, and we need to rewrite them when we do not like what we're seeing. So right here is a narrative by someone else that people often do not question, because they put their trust and belief in others who have not earned that trust and belief, and so they indoctrinate our little ones as to what is true and factual, and it takes people down a road that is just based on lies and not on using our own critical thinking, our conscience. We need to be awake in this life, and we need to take the reins in our own hands and the pen in our own hand, and have that story that we want to see, and to rewrite it. Like I said, we have that power. Let's empower one another. So anything that's not serving us, do not focus on it, because what you focus on, it grows. And so this is a process for all of us, including myself. So as I'm speaking into myself as well, and reminding myself that this isn't the end, and we can share what is helpful and let go of those things that aren't. So here it says the Missing Northwest on Twitter, and it says April 3rd, 2016. This page tweets about missing children and adults of the Pacific Northwest, as well as Amber Alerts from across North America and Washington, and goes into all these different states. So here is my youngest daughter on the far left, and then in the middle is my eldest, and then on the right is my middle daughter. Right here it says Missing Northwest are missing from Bend, Oregon since 2015 is what is being said. So that is very, very interesting, just looking at the dates of what they're saying, and I'll talk about this some more later. Okay, so here we have just in between, just information about, at the bottom it says Oregon's missing persons on Facebook. They had it posted everywhere. They were last seen together, and it says March 27th, 2015. At this time, and yeah, so there were a lot of lies used. And then here it says, abducted by their non-custodial mother and stepfather from Bend, Oregon on March 27, 2015. And then this was an update, and it says that they were found safely June of 2016. And if you look on this page, it's going over other children who are with their what they call non-custodial parents. And you can go down the page. I can't move it because this is a still shot right now, but it's talking about abducted by non-custodial mother and all this. So this gets into these kangaroo courts and how they are making decisions on who is a parent and who is not. And there is no true court of record, no jury of one's peers. This is being done by one man or a group of a private business association working together, where the prosecutor actually runs the whole show, and then the judge spews out what he calls a summary judgment, which are all completely unlawful. But we need to know about this. And says they were found in Mexico June. Let's see. So that was another one. Interesting. Let's see. Yep. So other people who knows the story, and do we really take the time to look and see what's going on, or do we look at these Amber Alerts and go into this heroic mode and call in to the so-called proper authorities and think that we're doing a good Samaritan type duty in order to help people? And sorry about the notifications on here. Anyways, we need to think before we do things, and think about what we want to be involved in and what we are going to be putting our energies and focus into, because those things that are tearing others down and not lifting others up, and when we are not fully informed, we can, without our knowing, be on the other side of the fence of, not being helpful, and we will be tearing people down, and we will reap from what we are sowing, whether we fully know what we're involved in or not. That's why it's so important to be aware and conscious of our actions, our thoughts, and our emotions. So I'm going to share this writ of mandamus, and it's a contempt of court. Anyways, this is a certified mail return receipt that was received by these courts, and I just wanted to show that it was sent out, and the petitioner is myself, and this is against Judge Lindsay Partridge, Judge Thomas Hart, Marion County Sheriff Jason Meyers, Attorney Phil Wiseman, and Oregon Attorney General Ellen Rosenblum. And there's others involved as well, but these were the main people that were actually noted just on the case on the front here. And this was done by the Unified United States Common Law Grand Jury that has been reconstituted into every county in America. And right now, many in seats of power are trying to silence this, and so we need to get the word out and let people know that yes, there are constitutional courts that are up and running, and they are ran by the people, and all of it is lawful, being done the way that it's supposed to be done, as it is written out in the Constitution. And that is the supreme law of the land, no matter what people try to come in and say. When the commercial codes came in and they said, okay, yeah, this stuff is going on, and we are going to be taking over, and this is now the new law of the land. Now, when things are done in fraud, it doesn't make them truth. So let me see here. Now, the Unified United States Common Law Grand Jury and their address, and then this is dated. which will show on the day that it was actually signed by the common law grand jury. And it says writ of mandamus, and it says the great writ of liberty is the writ of the habeas corpus. And I'm not going to read all the big words because I'm not going to do justice and say them correctly, but it says issuing at common law out of the courts of chancery, king's bench, common pleas, and extinture ex parte Kelly. In the United States, habeas corpus exists in two forms, common law and statutory. The Constitution for the United States of America acknowledges and sorry, I just kind of got through that and didn't say it exactly the way that it's supposed to be pronounced, but we're all human and that's okay. But up at the top here it says federal case number. It's 1776, 1789, 2015 de jure. And so it says people's rights to the common law of England as it was in 1789. It does not consist of absolute, fixed, and inflexible rules, but broad and comprehensive principles based on justice, reason, and common sense. Miller versus Monson. And then this is the case law. There's case law behind all of this. This is a well-known remedy for deliverance from illegal confinement called by Sir William Blackstone the most celebrated writ in the English law and the great and efficacious writ in all manner of illegal confinement. So I'm going to go into, now it says the U.S. Constitution, Article 1, Section 9, common law, the privilege of the writ of habeas corpus shall not be suspended. Now, everything that is put into this filing is important, and that's why I'm going to read through it. So people can fast forward, they can take what they want, but this is important because it is educating those who it is being given to the truth about how the process works and how law actually is, not what everyone has now made it to be in order to support a system that is oppressing people. So we stand upon truth, and that is what is important, not upon the lies. So that's where the light shines. So it says the 28 USC, and it's 2243, and there probably is a period in there somewhere. I can't see on this little screen, but statutory, issuance of writ, return, hearing, decision, a court, justice, or judge entertaining an application for a writ of habeas corpus shall forthwith award the writ or issue an order directing the respondent to show cause why the writ should not be granted, unless it appears from the application that the applicant or person detained is not entitled thereto. The writ or order to show cause shall be directed to the person having custody of the person detained. It shall be returned within 3 days, unless for good cause additional time not exceeding 20 days. Now the court must award and respondents must show cause. This Court of Justice has taken judicial notice of the Federal Rules of Civil Procedure, Title 28, United States Code, insofar as it is not repugnant to the common law, and its FRCP Rule 55 regarding default is applied here. The record shows that on January 15, 2016, the petition was filed, a writ of habeas corpus to show cause issued. The petition and writ were duly served upon the respondents. No return was filed. A notice of default was filed on January 22nd, 2016. So no claim may be made that the statutory courts were unaware of this court's proceedings, nor may the respondents claim they were unaware of the consequences for failure to make a return on the writ of habeas corpus. And then there's footnotes at the bottom that are very important, and it goes into Federal Rules of Civil Procedures, Rule 55, and defaults and entries, and by the clerk and by the court, and the settings aside of the default, and the courts of record. And I'll just read: the courts of record have an inherent power independently of statutes to make rules for the transaction of business. And so I'm not going to go into each of this right now, but if people want at a later date, I can read through the footnotes. But it says here at the top, continuing on with the consequences for failure to make a return on the writ of habeas corpus, simply stated, the parties against whom a judgment for affirmative relief is sought have failed to plead or otherwise defend as provided by these rules, and that fact has been brought before the court by affidavit in accordance with FRSP Rule 55 attached. Now, to intercept, conceal, or expunge habeas corpus is to deny due process, thereby warring against the Constitution, violating all of these USCs, it's just completely unlawful. So you have the 18 USC 2071, 18 USC 1001, 18 USC 4, and the list goes on. And it says, any judge who does not comply with his oath to the Constitution for the United States of America wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. Cooper versus Aaron, and that's 358 U.S., and then it just goes into the case law on that. Now, a writ of habeas corpus is a judicial mandate to a prison official ordering that an inmate be brought to the court so it can be determined whether or not that person is in prison lawfully, or whether or not he should be released from custody. A petition for habeas corpus is a petition filed with a court by a person who objects to his own or another's detention or imprisonment. The petition must show that the court ordering the detention or imprisonment made a legal or factual error. Petition for habeas corpus is usually filed by a person serving a prison sentence. In family law, a parent who has been denied custody of his child by a trial court may file a petition for habeas corpus. Also, a party may file a petition for habeas corpus if a judge declares them in contempt of court and jails or threatens to jail them. Now, in Brown versus Vasquez, 952, it says denied. 112 goes into different numbers. 1992, the court observed that the Supreme Court has recognized the fact that the writ of habeas corpus is the fundamental instrument for safeguarding individuals' freedom against arbitrary and lawless state action. Harris versus Nelson. And therefore, the writ must be administered with the initiative and flexibility essential to ensure that miscarriages of justice within its reach are surfaced and corrected. The writ of habeas corpus serves as an important check on the manner in which state courts pay respect to federal constitutional rights. The writ is the fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. Harris versus Nelson. This case law is so important to know, that these rulings have already stated what is so, and that when people stand up and shine a light on these facts, that they stand, and what the people who are coming against others, tearing them down, are just wanting is that we stay asleep at the wheel, and that we don't expose these things, and that we stay ignorant. And so in the midst of everything that we're going through, we must focus on those things that empower us and educate us so that we are able to see what is actually going on and to present it, to use our voices and to put it down on paper. We are the authors. So here, 28 USC, and it's 2242, every person unlawfully committed, detained, and confined or restrained of his liberty or property under any pretense whatsoever may prosecute a writ of habeas corpus to inquire into the cause of such imprisonment or restraint. The petitioner showed in this petition that the court ordering the detention or imprisonment made the following legal and factual errors, and therefore the writ of habeas corpus must be prosecuted. Respondents gathered a biased statutory grand trial jury, a jury not under common law, a jury under a court not of record. In other words, not at law, a jury which has no power to fine or imprison. Thereby jurisdiction was fraudulently acquired. There was no sworn documentary evidence from a competent fact witness. Petitioner is being unconstitutionally held by a court not of record, as required and defined under Article 6, Clause 2. Court is proceeding under statutes and jurisdictions unknown and not under the law of the land, aka common law. Court's jurisdiction was not stated as required by law. Petitioner was denied due process. Trial in a court of common law is due process. Petitioners are victims. The petitioner are victim or victims of, it's hard to see. Retaliatory maintenance of property. Custodians have engaged in prosecutorial and vindictiveness. Therefore, the burden is upon respondents to rebut presumptions. It's all about presumptions, assumptions, and hearsay. And they're not allowing facts to be heard in their kangaroo so-called courts. Now, the habeas corpus is due process. Let's learn a little bit about this. Title 28 of the United States Code, says acknowledges that it is not the responsibility of the petitioner to know by what claim or authority the state acts, but that the petitioner may inquire as to the cause of the restraint. Petitioner has requested an inquiry into the cause of restraint, but none of the respondents has returned any statement of cause of the restraint. Therefore, this court may and has presumed that there is neither legal nor lawful cause of restraint. On January 22nd, 2016, the grand jury filed a default of memorandum of decision of the default, and thereby the statutory court was ordered to abate at law. All proceedings in and relating to Marion County Circuit Court for the State of Oregon Juvenile Department defacto case numbers, and they have, of course, all of these case numbers associated with each child, and that is how they say it's all confidential and all this other stuff. But anyways, they go into this, and that's how they get into people's SESQB accounts and everything else. But the statutory against my family is what they have done to attack us. And so they bring in this court that looks like law and all these players involved, and we've been hoodwinked. And so this is what I'm doing and have done to expose the darkness, and I will continue to stand and to share, because this is not okay. This is going on all over the world, and they're hiding these true courts of record from the people. So we have to stand together, hand in hand, building bridges and breaking down the walls. So it says, basically, the above named statutory court ignored habeas corpus and has yet to release myself and all of my children and my family involved in this. my husband, all of us, from illegal custody. And it says, after reviewing this case, we have concluded the following. The court that prosecuted myself and my family was a statutory court, not a court of record, and therefore had no constitutional authority to incarcerate, to take from me, which is not theirs to take. They did not create my flesh and blood little ones, and nor me or my husband. And so, too, the grand trial jury was tampered with to secure statutory indictments and statutory prosecutions by said court, not of record, under color of law. There were no injured parties. There were no sworn affidavits. There was no due process, and this was a political case with vindictive prosecution. Because of the aforesaid conclusions and from information received in that, pressure is being applied upon petitioner to somehow stop the probing and actions of the grand jury. Let us be clear. The habeas corpus has endured over 400 years unimpeded. Once the petition for habeas corpus was received by the court's bench, grand jury, and acted upon, the petitioner's attorneys or statutory courts do not have power to stop the writ of habeas corpus. Therefore, vindictiveness has already been established, and we are therefore warning all involved that we will be reviewing the actions of all involved. In conclusion, Judge Lindsay Partridge, Judge Thomas Hart, Marion County Sheriff Jason Meyers, Attorney Phil Wiseman, and Oregon Attorney General Ellen Rosenblum are in contempt of court and are herein ordered to release Sherry, all of my little ones, and my husband, immediately as previously ordered by this tribunal, or we will bring this action before the full grand jury for judicial remedy upon all conspirators, including all court officers who are violating the aforesaid federal codes. This court is gracing Judge Lindsay Partridge, Judge Thomas Hart, Marion County Sheriff Jason Meyers, Attorney Phil Wiseman, and Oregon Attorney General Ellen Rosenblum with the opportunity to amend their error and abate at law immediately all proceedings in and relating to Marion County Circuit Court for the State of Oregon Juvenile Department defacto case numbers, all the ones they assigned in the statutory against Sherry and my family, and it's signed by the grand jury May 6th of 2016. So I wanted to share this. I'm going to break this up probably into some parts because I want to show you this wasn't the end. This was part of a bunch of paperwork that was put together lawfully in order to tell these people that what they're doing is unlawful and that they need to cease and desist, but yet they have continued to unlawfully ignore these superior orders by the common law grand jury that, like I said before, has been instituted in all the counties in our United States of America, which I don't want to get into the corporate type United States and all that. What I want to say is the actual America, the people, all the fraud that's happened. When I'm talking about the United States of America, I am referring to America, not the fraud. And this is what this paperwork is about. That there were orders way back in May 6, 2016, before they drug me into their so-called criminal, courts that they have today, on parental interference based on lies, presumptions, assumptions, and hearsay, and they chose to ignore what is completely unlawful, not okay, and it will be exposed and it will be investigated, and there will be reaping from what they have sown by them. All of us have to live in accordance with what we do. And so I thank you for taking the time to listen to me try to read this in the very small print, and that I hope that it's helpful and empowering to you as moms and dads and families standing up and coming against a system that is oppressing people, and focusing on those solutions that we can stand on to empower one another and to end human trafficking. Namaste.